If you slipped and fell at a store or someone's home, this is the video you need to watch to determine whether or not you have a legal case in Georgia, so stay tuned. Hi, I'm Michael Coker. I'm a local personal injury lawyer in Lawrenceville, Georgia, and I'm going to talk to you about slip and fall cases because slip and fall cases are very unique and very difficult cases. You see, about 25, 30 years ago, Georgia courts made slip and fall cases very, very difficult to win. And the reason was, way back in the day, people were going into grocery stores, pretending they slipped on a grape, and trying to create a fraudulent case. And so because of this, because there were a few bad apples out there, I believe the pendulum swung too far the other way. And so what that means is that now these cases are very, very difficult and very, very hard to win. And so you need an experienced lawyer who understands these type of cases. But basically, there's two ways that you can win a slip and fall case in Georgia. One, if you slipped and fell on some sort of item on the floor, whether that be water, whether that be milk, whether that be grapes, or maybe you even tripped over a frayed part of the carpet, you need to show one of two things. One is that either the store had actual knowledge of the danger or they had constructive knowledge of the danger. So what does that mean? Let's take both of those things and talk a little bit about it. So first, actual knowledge means that an employee at the location or a manager or someone else knew that that water was there and that they did not take appropriate action to fix it. And so let's say that you had an employee that basically looks over and sees at a grocery store a thing of spilled milk and goes, "I'm not cleaning that up," leaves, 10 minutes pass, you come through, you hit that milk, you slip and fall. Well, that's actual knowledge. That means that that employee had actual knowledge that that spill was there and failed to take action. Now, the problem with actual knowledge is that in most situations, the employee's not going to admit that they had actual knowledge of the milk. And so that's going to lead you into the constructive knowledge, the second way of winning your case. But if you have an employee that's honest and truthful and says, "Yep, I knew that was there, I didn't do anything about it," then that is the first way that you can help establish a case for a slip and fall. The second way is through what's called constructive knowledge, and that's by showing that that fluid or substance or whatever caused you to fall was there for such a significant amount of time that somebody at the store should have known that it was there. So what does that mean? Let's say that you slip and fall again on that milk, but let's say that nobody saw it. But let's say you hired a really good lawyer who understands these type of cases. And he or she sent what's called a spoliation letter to the store and preserved a copy of the surveillance video. And so your lawyer is a great lawyer, and they see that a young boy comes through and maybe spills the milk. And then maybe 10 minutes pass, 15 minutes, 20 minutes, 30 minutes, and that milk is still on the ground and no one has done anything about it. Then you come through and you slip. Well, guess what? You've just made a great argument for what's called constructive knowledge, meaning that that milk was on the floor for so long that some employee should have come by, should have seen it, and should have fixed the problem. That's constructive knowledge. And so you have the two types of knowledge that you can show. One is actual knowledge, meaning an employee actually knew that milk was there. The other is constructive knowledge, meaning that that milk was there for so long that somebody should have seen it and should have fixed it. A great lawyer is going to know the strategy for proving either actual or constructive knowledge. I already told you one of them, which is the video. You need to hire a lawyer after a slip and fall immediately because sometimes these stores, their video camera system, it can record over itself in 24, 36, 48 hours, whatever it may be. And so you need to make sure that your lawyer sends a notice to them that they need to save that video. And guess what? If they don't save that video like they're supposed to, that can help create what's called a presumption for you in court, meaning that might prove to the jury that that milk had been there for too long just because the store intentionally didn't save what you asked them to save. And so that's the two types of way that you can show negligence. Now, There's other defenses that the store can come through. They can say, well, we had reasonable inspection procedures, right? So take my milk example. We had just had an employee come through, sweep and mop that whole area. The kid comes immediately right after. We start to come around to do our next run, and that's when the person fell. So we did what we were supposed to. We had reasonable inspection procedures in place, so we should not be at fault. That's a defense, and that's something they can argue. And there's like 10 or 15 of these that they can argue. They can argue that you had already walked through the area, that you had already seen it, or you should have seen it, and you still fell. And so there's a lot of ways that these stores and these facilities can try to get out of paying you or get out of a settlement or try to win at court. And so that's why it's really important that you talk to a lawyer, because anything you say to the employees or to their insurance company probably is going to be used against you in court. And it's probably going to be used in such a way that they are going to be crafting one of these defenses to get out of any sort of responsibility. Keep in mind, these stores, these major grocery stores, these major retail stores, they have very high-powered and experienced lawyers. And so all they got to do is get you to say one thing so that your case is completely ruined. And so you need to immediately talk to a lawyer, immediately speak to someone so that they can handle the case and they can do the talking for you. The other thing that I'll tell you with slip and fall cases is you always want to report the fall to the store. So if you fall in a store, the first thing you want to do is immediately tell a manager or supervisor that you fell, point out the substance you fell on. And I always recommend, if you can, if you're not hurt too bad, take a photo of what caused you to fall, because that could be critical evidence later. Because again, you might have an employee come, see that spilled milk, go, oh no, I should have cleaned that, and quickly clean it up. And we don't know how much milk it was, how long it had been there, what it looked like, what color it was. And so that's something, if you can take a photo using your cell phone, that's always something that I recommend you do too, because these insurance companies love saying, oh, well, you know what? That milk was there, but it was 2 tiny, tiny dots of milk. And of course, you know it was a big puddle, but if you don't take that photo, we don't have that evidence later that we can use for your benefit. And so try to take a photograph, try to do what you can to make sure that that evidence gets preserved. So we talked about the 2 types of ways that you can basically prove with actual or constructive knowledge. We talked about the various defenses that a insurance company or a defense lawyer or a store might throw at you to try to avoid responsibility. We talked about reporting the incident to the store, and we talked about taking pictures. These are 4 kind of ways that you can help understand these type of cases, understand what's needed, and really understand why you need to talk to an attorney. These cases are absolutely not cases that you should handle on your own. Because again, you might say something, not even realizing that you're saying something bad, that ultimately ruins or even causes you to completely lose your case. And so I would encourage you to call a lawyer immediately. Call an experienced lawyer who has won these cases before, who's won these cases on what's called summary judgment, meaning where the judge looks at the evidence and says, does he or she have enough evidence to go to trial? Those almost always come up in these type of cases. Ask your lawyer, have you handled these cases? Have you done summary judgment motions on these? Have you argued these issues before? And if they tell you no, if they're a routine car accident lawyer, tell them thank you very much and call somebody else. I'd love to talk to you about the case. I'd love for you to call me, but you don't have to. My interest is making sure that you hire somebody who is experienced, who understands these cases, so you're protected against the high-powered lawyers of the store or the grocery store. And so that's some information about slip and fall cases that you need to know for your specific case. This is my podcast. Again, my name is Michael Coker. I'm an attorney who does personal injury in Lawrenceville, Georgia. And my podcast is called Georgia Legal Talks. If you like getting these updates about Georgia law and kind of understanding more how Georgia law works, I encourage you to like and subscribe. And we'll keep the updates coming so you can learn more and more about different legal issues that could affect you. And so until next time, I just want to tell you, thanks for listening.